Welcome to Brief Encounters and the February episode of the Securities, Regulation, and Enforcement podcast series. My name is Valerie Mirko. I'm a partner at Armstrong Teasdale, and I also chair the firm's Securities, Regulation, and Litigation practice. And with me is my co-host, William Nelson. William, will you go ahead and introduce yourself?
Thanks, William Nelson, Director of Public Policy and Associate General Counsel at the Investment Advisor Association. We're going to talk about a few things today, but one of the big things this week was Hill-related on Capitol Hill. So we had a hearing in the Capital Markets Subcommittee of the House Financial Services. For those who aren't as attuned to legislative process, this is the committee that has jurisdiction over the SEC, CFTC, Securities, Commodities. They had a hearing that was really focused on, and you can kind of tell by the name of the hearing what they're going to talk about. And it was a new day at the SEC, restoring accountability, due process, and public confidence. And I know, Valerie, today we're just going to talk about, kind of what was said in the hearing, but also some of our takeaways, both for practitioners, but also looking at it through the lens of, how potentially the Congress is, exerting their oversight of federal agencies such as the SEC.
That's exactly right. And, you and I have both been in the securities industry as lawyers for a long time. And looking back to the time leading up to Dodd-Frank, that was really the last time that we had hearings that had those titles and sort of that type of focus on the SEC's day-to-day business. I always find that interesting when we look at sort of the span of time and how things evolve with the SEC, that in some ways we're back to having some of the discussions that we had in the late 2000s about how should the SEC be doing its business, how does it work, and so forth. And it's been a while since there's been such a congressional focus on the SEC and its day-to-day business. I mean, the title says it all: restoring accountability, due process, and public confidence.
Absolutely, Valerie. And I think, one of the things that most excites me about this hearing and others is that historically in the U.S., unfortunately, we've been led by crisis-driven legislation. We got the 33 and the 34 Act after the market crash in 29. We had Sarbanes-Oxley after Enron, WorldCom, and then obviously the great financial crisis, 2008, 2009, gave us Dodd-Frank, which we actually started out this podcast really, looking at how Dodd-Frank came about, but then how it's evolved up until today. So I am really excited to see that Congress is being more proactive and really looking at the SEC in a relatively state of calm rather than, trying to play catch up after a financial crisis or something comes up, a black swan event where they really have to quickly put together large structural reforms in a really quick process.
That's exactly right. It is, in that sense, this hearing is unusual in that we're in a relative state of calm. Some of my takeaways from the hearing, there's a real, almost granular focus on how the SEC is doing business right now. There's parts of the hearing that discussed, parts of the hearing and the written testimonies, I should clarify, that discussed, for example, like how many direct reports should the SEC chair have. One of the witnesses brought up the idea of a vice chair and noted in his testimony that, and this was Alex Cohen's testimony, by the way, if anybody wants to look it up, noted in his testimony that when the SEC was founded, it did not oversee as many issues as it does today, and therefore that the governance structure needs to evolve. So I thought that was really interesting that it would come up in the congressional aspect, meaning as we're discussing bills about the SEC structure and how the SEC does its business, that's a pretty granular point, that there's such a focus on how the SEC is being run and wanting to optimize it.
Yeah, no, and those are really great points, Valerie. And I think some of my takeaways are along those same lines, but also what I found really interesting is that, some of what they talked about related to, cost benefit analysis, notice and comment rulemaking, things that are already in place under the Administrative Procedure Act. and frankly, things the SEC, should be doing in their rulemakings. It's really just, having this additional legislation that would, reinforce existing duties that the SEC already has. So I thought that was really interesting as well, just how Congress, in their oversight capacity, could move forward some of this legislation that would only enhance what the SEC is currently doing.
And is already in some ways required to be doing. It's almost this sort of hardwiring further structure to ensure that things that at times do already happen are actually hardwired into the process. So a couple of examples there. There was a discussion about the importance of cost-benefit analyses. And as you and I know, all SEC rules go through a cost-benefit analysis process. Its robustness can vary. Its robustness and sort of its accuracy can vary. I've definitely had conversations with clients where, we're all looking at a potential rule proposal and its impact, and the cost benefit analysis just comes up short. But then there are other times where the cost benefit analysis is actually pretty realistic. So I think that renewed focus on cost benefit analysis, renewed focus on having longer comment periods, those are all things that at times the SEC does and does very well, but it is not as consistent as we would want it to be, as, in my case, as a defense practitioner, in your case, as somebody who is on the government relations side, as well as the industry trade association side of things.
Yeah, absolutely. And I think to your point, Valerie, too, it's the pace of the rulemaking, but I also think the interconnectedness. And I think this is something where, I know we've heard a lot about cumulative impact of regulations, and that was another focus of the hearing. Really, the SEC should consider overlapping impacts of proposed regulations. How do they interact with each other? I think that's really important too, because sometimes, and it is difficult, right? Because a lot of proposed regulations, you're just estimating, what the outcome will be because they're proposed. They're not final regulations. They haven't been implemented. So I think that focus on interconnectedness and cumulative impact is also really important.
Yes. And that hit an inflection point when we look at the 13 or 14 rule proposals during the Gensler era that were ultimately withdrawn. There were 3 or 4 of them on the Advisors Act side that were all so interrelated and even had to some extent almost like a duplicative factor. And yet that did not seem to be considered in any of those proposals. I'm thinking specifically of the outsourcing proposal, but then also, the vendor management component of the cyber proposal. But then you layer over that as well aspects of the then custody rule proposal. And those were all very interconnected, but there was no acknowledgement in any of the proposals to that effect.
Yeah, absolutely. And I think also, too, they kind of had 3 goals from this hearing, restoring accountability. We've already talked about that a little bit through notice and comment, through cumulative impact. I'm definitely really interested to hear your thoughts on due process through enforcement reform. But the third message, which is also very interesting, was really prioritizing transparency.
And how transparency ties into public confidence.
Exactly. Yeah. And one of the main topics related to congressional oversight, which again is Congress's job to oversee the federal agencies, and one of the pieces of legislation they discussed was semi-annual testimony of the SEC chair before the House Committee on Financial Services. I think to a reasonable person, this would make sense, right? If you're the SEC chair and you're being overseen by the committee, you should probably be testifying at least once or twice a year to keep them apprised and the public apprised on what you're doing. And I also think increasing public access. This is one area where I have seen the SEC make incredible strides, multiple roundtables, reaching out to industry, really trying to get their feedback. I think that's one thing where the SEC could definitely be commended in that area.
I think that's right. But you're right, William, in that even though we've talked about all these other topics, the most interesting topic to me in connection with this hearing was the due process component. And of course, addressing the deficiencies of regulation by enforcement, which is a topic we've spoken about in past episodes as well. I've also co-authored a white paper for the Financial Services Institute with actually one of the witnesses, Peter Chan, one of the witnesses from the hearing. We co-authored a white paper a couple of years ago about all of the problems of regulation by enforcement, and as well as what would a solution look like. That was also addressed in the hearing this past Wednesday. But simply put, I thought it was very encouraging based on the questions that came up at the hearing that there is a real concern within the committee about regulation by enforcement, that there's a real concern about wanting to have better due process for targets of investigation. And there was an acknowledgement that, this is an issue that Chair Atkins has been looking at as well. And of course, we've talked about the Chair Atkins speech regarding reforms to the Wells process. The speech occurred in October, and I know we talked about it in our, I think, October and November podcast episodes. So I think there is appetite for reforming regulation by enforcement at the commission level currently, both that October speech on the Wells process, but also additional speeches and signaling since have shown that this is a commission that is not interested in regulation by enforcement, which is obviously a very good thing. But the hearing and the subcommittee, the capital markets subcommittee that oversees the SEC, really showed that the conversation is about more than this current commission. There's a real concern that, even if there are reforms to avoid regulation by enforcement in this commission, that this is a concept that could return with a future commission, especially should there be a party switch in the White House and then at the commission level. So I think it is very healthy that this subcommittee and ultimately House Financial Services as a whole, because the House Financial Services Committee chair was also at the hearing. So it was not exclusively a subcommittee hearing. There was sort of the presence from the committee itself. I do think it would be very helpful that in this time of relative calm, that there be actual reforms that hardwire due process reforms at the SEC to avoid regulation by enforcement, past this commission. We know this commission's not interested in regulation by enforcement, but we don't know what the future will bring.
Yeah, no, and I think that's a terrific point and a very important one because, the industry, yes, we talk about regulations, we talk about compliance costs and burdens, but the thing that, really concerns the industry, at least from what I hear from our members, is inconsistency and the unknown. So, when you do go back and forth from administration to administration and you have such different viewpoints on how to enforce the securities laws or how to conduct the rulemaking process, the other thing before we talk about a few other issues we're going to get to, I did feel like there was a sense of bipartisanship. Obviously, in these hearings, they can always get heated. If you saw the hearing with Treasury Secretary Bessent, a little bit more heated than the subcommittee hearing. But I did find that, even Democrats, Republicans, there were very good questions. And I think everyone wants to get to the same place of having that consistency, but also, just like, the title says, accountability and transparency, I think is so important. So overall, again, I think it was a really important hearing, and hopefully going forward, we'll see some of those reforms implemented.
Like you said, it's an important hearing, and it's notable for the fact that this type of hearing is occurring during a time of relative calm and has a bipartisan note, again, in a time where bipartisanship is not necessarily happening around a lot of issues. So these are all encouraging. There are several bills that were also noticed in connection with the hearing. So it'll be interesting to see which ones progress and which ones don't. But if nothing else, I think we have a pretty good sense of how House Financial Services broadly thinks of where SEC reforms should be going. And we have a lot of insights into the subcommittee that oversees the SEC and their concerns. So I think that will be interesting to see how it plays out.
Absolutely. Well, It seems in this day and age, you can't go through a podcast without talking about crypto. So we know recently that the SEC put out several statements over the last few months related to, meme coins, related to crypto mining. Their most recent statement was back on January 28th. So it has been a week now. We've had to digest it. A statement on tokenized securities done by 3 different divisions: corporate finance, investment management, trading and markets. Basically, the goal of this was just an effort to provide greater clarity around what we call tokenized securities. But Valerie, I'm really interested to get your viewpoint, what you thought about the statement, but also maybe how firms are looking at it from a legal and also compliance standpoint.
No, absolutely. And it's, this statement, first of all, shows that there's good coordination occurring between the various divisions and between the staff. So I think that's a very positive thing. I think overall, the SEC's been clear about where their jurisdiction lies on digital assets, i.e., solely when those assets are tokenized securities. So what we're seeing here is further focus on the applicability of existing securities laws on digital assets. And the theme really continues because we're seeing, this is providing the staff view of the way that tokenized securities can be and should be integrated into the current regulatory regime. It's really following the same theme that we saw, for example, with the SEC's 2026 exam priorities, which treated crypto and digital assets, frankly, in the same manner as many other financial products that are out there. And sort of that theme continues with this staff statement on tokenized securities. I also really like how this latest staff statement is done in plain English. It's very explanatory. I think it is very useful for industry and provides a measure of comfort. Because, William, something we talked about earlier in today's episode is there's been a lot of uncertainty when it comes to policy directions, particularly around crypto, over the last 10 years. And I think as, we're seeing more certainty towards the legitimization of crypto and digital assets, we're also seeing other indicators, such as the staff statement, that really just consider tokenized securities yet another product and explains where it fits into the existing securities laws and regulations. So overall, I think this is a very positive development. Curious for your thoughts, William?
Yeah, no, and I agree with everything you just said. I think it's very positive. And I also think that it's an acknowledgement by the SEC and its staff that, yes, we've been talking about cryptocurrencies. Apologies for those who are holding Bitcoin right now. I think it might have just gone below 60,000, and all these different coins. And they've come out with guidance on meme coins and mining. And I think there's a real acknowledgement now that there's more of a focus in the industry on this issue of tokenization. You already have securities, but now they're just being tokenized. They're being put on the blockchain, and they're, just different ways that investors are interacting with securities. It doesn't change that it's a security. It's just being done in a different way. So I was really encouraged to see the SEC really focusing on this issue, because now we're seeing, more and more even larger institutions really looking at how can you tokenize these securities, and, how does that affect trading? How does that affect custody? There's so many questions that need to be answered. So I thought this was a really good first step by the SEC saying, look, yes, we know all about crypto assets. We know about all these different coins, but at the same time, we are seeing this move now towards taking, traditional security and just, having it on the blockchain.
Completely agree with this. This staff statement is very consistent with what we've seen from this commission on crypto, and a very incremental, measured approach towards all components of crypto and digital assets, sort of as an industry, as an ecosystem, and seeing incrementally, whether it's through staff statements, which is what we're seeing now, but also through commission signaling, through speeches and roundtables and so forth, both the legitimization of that industry sector, but also the fact that at every turn, we're seeing how it can fit into the existing federal securities laws and regulations. And we're getting validation or affirmation through staff statements that it is indeed possible, that we do not necessarily need a whole other regime. Because being able to fit crypto and digital assets regulation within existing regulation also helps hardwire that certainty for the industry, because then there is not that feeling of, well, should we be waiting for another rulemaking? Because with rulemaking comes uncertainty. So I think we're seeing this sort of very incremental, measured approach towards bringing certainty for this part of the industry.
Yeah, and that's absolutely right, Valerie. And, we're still waiting on Congress. They passed their stablecoin legislation last year, very limited to those specific types of assets. We're still waiting on market structure. I know that the Senate's had some issues, and there's also an issue of jurisdiction with different committees having to kind of patch their different bills together. But it is good, now that the SEC just really focusing on how these types of assets really do fall under the current securities laws. We talk a lot about the SEC on this podcast, but we also have a very important SRO, FINRA. They've been going through a whole rule modernization process, which I think has been really fascinating to watch. But Valerie, you're much better equipped to talk about it than I am. So I was just curious, what are your thoughts on some of the recent actions that FINRA's taken?
Absolutely happy to chat briefly before we wrap up. The most interesting proposal to me right now is the fact that FINRA filed a proposal with the SEC, which, as everyone who listens to this podcast knows, FINRA rulemaking has the FINRA notice to member segment of the process, but then it files the proposed rule with the SEC for the SEC to approve. So there's essentially two rulemaking segments when it comes to FINRA rulemaking, in a way that does not usually occur with SEC rulemaking. And that's, of course, putting aside reproposals. So we're at the second segment point with this FINRA rulemaking on outside business activity. This is something that the industry has been following very closely. And some of the changes that we're seeing between what I'm going to call the notice to member proposal versus this version. Of course, the notice to members was 2505, if anybody wants to look that up as well. But the difference with this proposal that went to the SEC is that it further and significantly reduces the scope of reportable outside activities for broker-dealers. It's narrowing the disclosure requirement to only apply when the activity undertaken by associated and registered persons is considered to be investment related. I think that's a really helpful thing. The reality is most people in the financial services industry do have a lot of outside business activities, and only the investment related ones are truly relevant. So I think acknowledgement by this proposal of that is very helpful. There's also further clarity about an associated person of a broker-dealer and their activity with an unaffiliated registered investment advisor in terms of how that is handled. Specifically, it's a departure from the current guidance, which currently requires FINRA members, meaning broker-dealers, to supervise and record transactions of an associated person's activity at an unaffiliated registered investment advisor. The current proposal moves away from that. So that, I think, is very helpful. It just, at this point, that activity would be treated as an outside activity of the registered person. It would be subject to prior written notice, but that would be it, so to speak. And I think that it's a right sizing of how to handle these types of outside business activities. And then further, the current version of the proposal, which I should add, none of us really expect to change at this point, but there are additional several exclusions for low risk activity, meaning activity performed at an affiliate. Specifically, it also further permits broker-dealers to seek exemptive relief under the rules for certain situations. So there's a lot of additional flexibility that is being built into this current version of the outside business activity oversight paradigm, so to speak. To be continued in terms of when that is adopted, when there is an implementation date. But overall, I think it is a very positive development in terms of right-sizing the outside business activity framework to only activity that is investment related and not going too broad, but instead having the correct approach, focusing on investment related activity and not requiring supervision and transaction recording of transactions at an unaffiliated RA, and also building in further exemptions. There's a lot of flexibility built in, and overall, that's a good thing.
Yeah, absolutely. And I think that, all of this, again, I think goes back to our broader discussion, modernizing regulation, increasing transparency, increasing accountability. We've seen that with the SEC, and it's, going out to the public and the industry. We've seen that at FINRA with their modernization proposals. And also now we just talked about how the Congress, specifically House Financial Services Committee, is also really focused on this issue. So I think it's definitely an overall positive, and I'm really interested to see, over the next few months, kind of where this ends up. It seems like there is momentum. So hopefully, it's an election year, anything can happen. But I am optimistic that, we may start seeing some of these, both proposals, but also reforms come into fruition.
I think that's right. And something we did not mention when we were discussing the hearing is, while the hearing on February 4th focused largely on the SEC, there was also discussion around FINRA and the PCAOB and where they fit into the structure. So this scrutiny of how regulators are doing their business is not just about the SEC. It went a little more broadly at times in the discussion. So it's interesting to see alongside that what FINRA is doing with its rule proposals, and really focusing on the FINRA Forward initiative in terms of simplifying and right-sizing and finding a path forward.
Absolutely. Well, again, Valerie, another terrific episode. I just want to thank you so much, thank our audience, and I really look forward to next time and continuing our discussion.
Absolutely. We will return in March, hopefully with another guest speaker. And until then, till next time.